My name's Al Gerhardstein. I'm a civil rights attorney based in Cincinnati. I've practiced for nearly 50 years, and I have represented victims of discrimination, LGBT clients. I represented abortion providers for over 30 years. I represented a lot of prisoners, a lot of victims of police abuse. General First Amendment issues have been on my portfolio, and just a full range of civil rights cases. I was born in Northern Ohio, in Cleveland, in 1951.
What was it like growing up there in Cleveland? What part of Cleveland?
I grew up just outside of Cleveland in a suburb called Bedford, and then we moved to Geauga County, and I actually, for my young adult years, lived on a chicken farm, and we produced eggs for a supermarket chain. And it was actually a great contrast because most of the people that lived and worked in that area were Amish. So we had a good exposure to the good work ethic and the interesting and unique perspective of Amish people who worked on our farm and lived in our neighborhood. And I got to witness that throughout my high school years.
What were your parents and your family like? What was your family makeup?
I have 5 siblings. 2 of them have now passed. My mom was a nurse. My dad was a truck driver and ran the chicken farm. And he was a World War II vet. And I just came across my mom's scrapbook from his World War II experience. And on my brother's 80th birthday next week, I'm going to present him with a new and revised copy of the scrapbook tracking my dad's journey across France as a medic and the liberation of a POW camp.
Wow, what an incredible heirloom to find.
Yeah,
wow.
It's really, really interesting.
You should have it digitized.
Yes, it is. That's what's happening.
Okay.
I actually took the scrapbook. I have an archivist here in Cincinnati who's going to present it to me this afternoon with the thumb drive, with the digital copy and the printed copy all done. So I'm pretty excited.
Oh, that's wonderful. So you talked about growing up on a chicken farm around Amish folks. Can you tell me any more about kind of your community or where you went to school in your young years?
It was a country school. I did my junior high there. I then went into Cleveland to go to a Catholic all-boys high school, and because I thought maybe I could get into college better if I took it up a notch. And I stayed with relatives during the week and only came home to the chicken farm on the weekends. And I had a good, experience. The school was great. I learned a lot. It was kind of rigidly Catholic, and as I actually took what they were teaching me to heart and wrote papers that were critical of Catholic doctrine, I would get good grades and then a warning about going to hell, all of which helped me decide to leave the Catholic Church, but on good terms, because they gave me the brains to figure out that this wasn't for me.
There's some poetry in that. After high school, you said with your intention to get into college, what colleges were you seeking out? Where did you go after that?
Well, I had a choice between Kent State and Beloit College, and Beloit is a small liberal arts college in southern Wisconsin, and I got a scholarship that made Beloit the same price as Kent, so I went there. And that was one of the first times I was out of Ohio. And it was great. I learned a lot. It was just the right size to become a leader, to have my voice heard, to develop those skills that I've used ever since. And I have stayed in touch with that college continually for the last 50 years. And am now on the board of trustees.
What did you study? What was your technical field?
I was a government major. It was the time of the Vietnam War, so I led a student strike, and we did all kinds of teach-ins and opposition to the Vietnam War. We worked in the community to try and bring local residents along on our journey of political persuasion. There was a lot of tension, but I thought it was a healthy debate, and at least from my perspective. And it was a very exciting time to be in school. And to this day, the school properly is a host for diverse views, for challenging people to think critically and to have their voice raised up for what they're passionate about.
When you were studying government, were your intentions to be a lawyer? What did you see yourself doing?
I actually was most interested in going into local government. I thought it would be a fascinating career. But on my watch, as a developing student, government was abusing the rights of too many people. So I decided to become a lawyer and sue government. And that's what I've done for my whole career, is sue government to try and hold it accountable, to reduce the oppression and the discrimination against folks. And I've been busy, unfortunately.
Yeah. If you can't join them, beat them. Right?
Yeah.
You actually just kind of answered this, but my next question was, how did you become interested in being, specifically a civil rights attorney? You kind of just talked about that, but is there anything you want to expound on there?
Well, I was very wary of the law. I just thought legal training itself was brainwashing. And I only saw the law as a vehicle for reinforcing property rights and propping up capitalism, none of which I was interested in doing. So I refused to take the LSAT. I wrote a letter to all these different law schools saying, I'm not going to take your test. You guys are, just spreading bad economics, and I think you should accept me as a student just because you need diverse views. And of course, and by the way, I'm not going to pay your entrance fee because that's just sucking money out of people who don't have it. And of course, I got rejected by every law school I wrote to except NYU, which wrote to me and said, you sound like somebody who would be a good candidate for our Ruth Tilden program. And that turned out to be a public interest scholarship. I ended up getting into the school, going there on a free ride, and that was absolutely transformative. I could never have been a civil rights lawyer if I had a student debt from law school. And so that changed my life and really gave me the tools to be able, not only the great legal training, but because my stereotype about law school turned out to be wrong, but also that debt-free entry into my career made it possible to take very risky cases and not worry about where the next dime's coming from.
Wow, what a story that you just got into NYU on good argument.
Yeah.
Yeah.
Well, they did make me take the LSAT, but they told me it was just to make sure I could think. And later I sat on the admissions committee and I agreed that it wasn't a distorted use of the test. So it was okay.
Can you tell me, what year did you graduate from Beloit? And then what year did you graduate from NYU? Or
graduated from Beloit in 73, graduated from NYU in 76. So Watergate was in full bloom during that period. And it made me very, very committed to being part of the effort to prevent those in power from abusing their power.
Throughout this time and then after your time at NYU, what other cases or projects did you work on that stand out?
Well, I had a couple of opportunities, both as an undergrad and as a law student, to have some really meaningful law-related experiences. One is the former Secretary of Labor is Willard Wirtz, or was Willard Wirtz. He worked with John F. Kennedy and Lyndon Johnson. And he was appointed as a trustee to the Penn Central when it was in bankruptcy. And as a field term from Beloit, he accepted me as a clerk in his office. And so I got to learn how a failing railroad with a huge labor force and a union could reorganize itself and serve the people better. There was a whole big transportation arm of the railroad that they wanted to just dissolve, but he wanted to save it. It actually became Amtrak. So just seeing some of these big picture issues and seeing the creative way that they used the facts to create like a semi-public corporation, which is Amtrak today, was fascinating to me. And then I also worked at a place in New York representing people who were ex-offenders, and we tried to get them taxi medallions, which were very important to your career, and you couldn't if you had a criminal record. So we were suing, saying old criminal records and related criminal records shouldn't matter to whether you can drive a taxi. And we took a case all the way to the U.S. Supreme Court, the Beezer case, and lost. And that was pretty disheartening. But I got to see it from beginning to end and learn the ins and outs of and the risks of law reform litigation. And then I also worked in Chicago for a while at a place called the Foundation for the New Business Ethic. And I would visit the Stateville prison. This is right before law school. And I would interview inmates, help them with their civil legal matters, usually divorce, family, custody, those types of things, and listen to their stories. And was very moved by how many practical problems they had that nobody was paying attention to. And I really was very inspired by that work. And to this day, I've always represented inmates. I started a nonprofit called the Ohio Justice and Policy Center. We do inmate work. We do jail reform, prison reform. And just as an aside, my daughter called me last week and announced that she was my clone because she had just filed her first civil rights case against Stateville Prison, where I had been visiting as an undergrad. So she thought that was pretty cool, and I did.
So you said that was right before law school. And then in law school, what did you work on that stands out to you?
Well, the Beezer case was in law school. And what I really did in law school that was so important was that I learned to try cases. I took every clinical course I could take. I took trial practice. I knew that I would end up going somewhere in the Midwest. I wanted to be a civil rights lawyer. I knew I'd have very little supervision, and I had to come out being able to try a case. So I did a lot of criminal cases in the criminal law clinic. I took every opportunity I could to learn evidence. And I also took all the boring cases or courses. I learned corporations and tax and all the things that are the cornerstones of power, so that I would be able to judge when power is being abused and understand how things are being manipulated to oppress people. So I was busy being a student in order to attack the forces that I thought were wrongfully deployed. And it all paid off, because when I got here to Cincinnati, I needed all those skills because I was busy right away.
That's really brilliant. That's a brilliant approach. After law school, then what? And how did you get to Cincinnati? Can you fill that time?
My wife is a teacher. We had good friends here in Cincinnati. We knew we wanted to come back to the Midwest. I had a Reginald Helber Smith Fellowship to work at Legal Aid. So I worked at Legal Aid for a couple of years. I was happy at Legal Aid. I was doing good work. It was good civil law reform work. But then I went to do an employment discrimination case on behalf of African Americans who were discriminated against by the Kroger company. And after I filed the case, the head of Legal Aid came to me and said I wasn't allowed to do the case because Kroger was a big donor to Legal Aid. And, I'm like, well, this is what we do, right? I mean, we just right wrongs. So what are you saying? And he said, well, there are some places that we just can't touch, and Kroger's one of them. So I quit and became a private civil rights lawyer.
How did you meet your wife?
We met at Beloit. We got married right before graduation and have been married for over 50 years.
And you said she's a teacher?
Yes, she retired recently, and we live in the Twin Cities now, and I still have an office here in Cincinnati, so I go back and forth.
When you arrived in Cincinnati, you said you were working with legal aid and that instance. What else were you working on in Cincinnati? And then I don't know if this is close to the time you were working on Article 12 and that work.
No, we came to Cincinnati in '76. I joined Bob Lothman in civil rights practice in '78. We were doing a lot of housing discrimination cases. We were doing a lot of sex harassment cases that was just developing as an area of law. And we were doing we were starting to do police misconduct cases. And then I was doing a great deal of employment. And there were areas of employment where the civil rights statutes didn't protect people. So, like gay rights. If you look at Title VII back in those days and to this day, there's no explicit protection for gender identity or sexual orientation. Since then, in 2020, in the Bostick case, the U.S. Supreme Court said sex discrimination includes sexual orientation and gender identity, but not in those days. So I was trying to develop theories to protect gay people from discrimination without any statutory protection. And we used handbooks where the beginning of the handbook, the employment handbook would say, we want to be fair to everybody. We think, it's important that if you have a problem, come to the manager, and we pledge ourselves to equal opportunity. So I would sue based on that pledge, saying they broke it and that was a contract, and we had 0 results. I lost every gay rights case I filed for years. And a number of my cases involved gay ministers, Presbyterian ministers, where I would go I had to learn the Book of Order, and I tried to go before these church councils and represent people who were being outed and had done nothing wrong, but their status made them targets to be thrown out of their pulpits. I was a miserable failure. And then I went up to Cleveland, and my brother, who's gay, had moved in with his partner, and his partner taught in an all-girls Catholic high school. And he got fired. And I represented him before the vicar of education in the Cleveland Archdiocese, and I said, first of all, what better protection do you have for the young ladies than, this gay guy? So I don't even know what your basic problem is. But secondly, tell me again what the problem is. My brother moved in with him, and they said, well, they must be having sex, and, it's just a bad morals. And then we went into various parts of the New Testament. We tried the canon law. I learned lots of obscure areas of the law and lost that case as well. So these were very, very depressing times. The only good part of that was that my mom was out on the street protesting, which I thought was really cool because she had never done anything like that. So we were and that's I mention that in part because it showed that minds were changing. So much of the oppression of gay people comes from a complete misunderstanding of all of our values and a rejection, just an assumption that they can't share our values. And that had to change. And that has changed in part over the years, but not by standing still. By protesting, by educating the public, by bringing failing lawsuits, and staying at it. And I spent 20 years losing cases, but hopefully educating the public some in the process.
That's the tenacity it requires, right, to get the big win.
Yeah.
Yeah. You said you went back to Cleveland. What year was this?
Oh, I just went up there I did cases all over Ohio, so I represented my brother's partner in Cleveland.
So you kind of left off. You were working in the 80s, on different cases. Can you walk me to the time that you got involved with Article 12?
Yes. So in '92, a group of us, and probably for a year or two before that, assembled from our just work in the community a whole bunch of stories, testimonies of gay people being discriminated against in employment, in public accommodations, in housing. We presented all this to City Council. And our goal was to get a local human rights ordinance as part of an effort to plant these human rights ordinances in cities across Ohio toward amending the Ohio Civil Rights Act to include sexual orientation as a status that was protected. We got that human rights ordinance passed, and the remedy wasn't very strong, but it was a first step, and we felt good about that. That immediately triggered a huge backlash. And with a lot of outside funding from Colorado mainly, there was a huge movement to not only repeal the human rights ordinance, but amend the Cincinnati Charter, which is like our own little mini constitution, to add Article 12, which was a provision that basically denied all rights to gay people, and said you couldn't even pass laws that would protect gay people, and you can't even bring them up. And that passed. I actually sued to take it off the ballot. That didn't succeed. It passed with about 64% of the vote. And so we became the first city in America to have this anti-gay charter amendment, and we were the city that led the country in hating gay people and literally imposing these legal restrictions on gay people that didn't exist anywhere else. There was a companion, sort of a similar measure, that had amended the Colorado state constitution, and that was actually struck down by the U.S. Supreme Court eventually. And I sued on behalf of a wide range of clients to have it struck down in Cincinnati. We won at the district court level with a really interesting trial that sort of explored what it means to be gay, and we had historians, we had psychologists, we had all these experts testify, we had testimonies from people who needed these protections. Judge Spiegel was very deliberate in his pursuit of the case. City of Cincinnati didn't seem to want to defend the law that vigorously, so they let this group from DC come in who were real silver-tongued, double talkers, and they were very vigorous in defense of the law. Equal rights, not special rights, was their name. And we won at the district court level. We lost at the Court of Appeals level. I took it to the Supreme Court. They vacated the Court of Appeals ruling in light of their decision in Colorado, sent it back to the Court of Appeals, which left their decision intact. So we had lost. So I went back to the U.S. Supreme Court, and they wouldn't hear the case. So, if I had always said, you really can't rely on lawyers to defend all your civil rights. And while I do my best, this was a great example of working hard, doing the best we could, having at least one round of good decisions, but then ultimately losing. So as of 97, it was very clear that Cincinnati was going to remain the only city in America, this island of hate. And it was pretty depressing. And so local folks organized, and we helped educate the public as to how awful it was. There was a huge boycott, and that had some impact. There was a lot of calling out of local corporations. There was calling out of stages that people wouldn't come and entertain at. So normal people using good economic political organizing started saying, well, we're going to take this into our own hands as we work toward a repealer of Article 12. And finally, in 2004, this went on the ballot. And in the same year, 2004, that Ohio passed the gay marriage ban, so the gay marriage amendment banning gay marriage to our state constitution, we in Cincinnati repealed Article 12. So a very focused local campaign, totally inconsistent with the results of the statewide effort on gay marriage. Just goes to show you have to be super vigilant at all levels.
And that progress is not linear, of course, that you take steps forward and backward simultaneously.
Absolutely. Civil rights is not linear. In fact, right now I'm representing trans people in Minnesota where I'm anchored. And I'm seeing the same hateful ads you saw in the last national political campaign, the same hateful ads and comments about trans people that we saw about gay people as we were trying to assert arguments for civil rights and gay marriage. It's just an othering that is withering. It's horrible.
I think it's all they have sometimes, right? To other. Well, yeah, my final question of this sort of biographical piece, unless there's anything else you want to add, is how did you ultimately meet Jim, and how did that get started?
Well, I've always stayed in touch. For a long time, Cincinnati was a very conservative town. Now it's turned more blue. But in my day, our only friends were legal aid lawyers. And they were like our moral buddies, and we raised our kids together. We're still buddies, and we still get together several times a year. And so I was at a legal aid party, and I had just read the Windsor decision. And the Windsor case was huge because it said that if gay marriage is entered into in a state where it's legal, then the federal government has to accept it. And the Federal Defense of Marriage Act was unconstitutional because it had banned the federal government from recognizing gay marriage regardless of the validity of the marriage in the state from which it came. And I thought, wow, that is really fascinating. And I was telling my legal aid buddies, finally, this might be a gay rights case that I could win because Ohio does that. If you're a 15-year-old, you can't get married in Ohio without parental consent. But you could get married in Georgia. So you could run off to Georgia, get married, come back, and Ohio would recognize that marriage. And I said, that's kind of like the DOMA. So, and the same thing with first cousins. First cousins can't get married in Ohio. But if you go to Massachusetts, first cousins can get married there, come back, and Ohio will recognize the marriage. So I said, it'd really be cool to have a client who was married in New York, because there were like 5 or 6 states at that time, that actually 9 states, I think, that actually had gay marriage, and then represent them as they tried to have their case, their marriage recognized in Ohio. And a friend of mine at the party said, well, you should meet Jim and John, because they're just going through this, and they just went to Maryland to get married, and it's going to be in the paper tomorrow, because the Enquirer sent along a reporter and a videographer. So she introduced me, and I had the opportunity and the honor to meet Jim and John and talk about what the impact was going to be in Ohio of their Maryland marriage. And that started our journey.
So Al, thank you for taking us through your motivation to take on the case with Jim. Can you just walk us through maybe just some of the guideposts that moved you from representing Jim to getting up to the Supreme Court?
Well, first of all, if you're going to use the law to promote social change, you need to know how to get a TRO, because civil cases generally take years. And if you just file a case and wait for the court to come knocking and say, are you ready to try your case, you'll be dead by then, because they just take too long. So my specialty as a civil rights lawyer is figuring out how to get a case positioned so I can say this is an emergency and we need to get to the top of the docket. We need a ruling right now, and everything else has to be put aside. And that isn't too hard to do if you're in the middle of a prison and you've got First Amendment rights on the stake, or you've got voting rights, or you've got sex discrimination or abortion rights. And so I've filed a lot of cases where we could legitimately claim the need for an emergency ruling. In this case, Jim and John posed that same issue because John was dying. And what was remarkable about this couple is that they had other things to do. They were saying goodbye. They were grieving. They were witnessing the end of a couple decades relationship. And they were celebrating a recent marriage. I mean, they just got married last week, for God's sake. And then I come in with a single piece of paper based on my other litigation. I knew exactly how Ohio would fail to recognize their marriage. When John died, on the death certificate that I was showing to Jim and John, John would be listed as single, and where it says surviving spouse, it would be blank where Jim's name ought to be. And I explained this to Jim and John when they wanted to know what the real impact was. And, they had a couple reactions. I mean, one was they were angry. They were happy that the federal government was going to recognize them. They were happy to say husband and husband all the time. They were cute and lovely and dear. But here in this most important last document memorializing their life together, and the only document, the only opportunity to memorialize their life as a couple, a legal entity in Ohio, it was going to be wrong. So they were going to squeeze in a lawsuit in the middle of all this other stuff right before John died. And that was heroic. And I didn't take that lightly. I just thought, wow, you guys are something else. Because I would totally get it if they said, can you go find somebody who isn't quite close to dying, to do this case? But they embraced it. And so we filed, I don't know, I think it was like less than 2 weeks after they got married, we're in court. And John was with it enough. Still, he was in hospice, he's in a bed, but his declaration was part of the lawsuit. And Jim filed a declaration. Jim came to court to testify. Jim had everybody in the courtroom in tears as he told their story. And you just got the sense that this really was important. I mean, this is what's government for? If it isn't to affirm our cornerstone institutions as a civil society, like marriage, if it isn't to protect the vulnerable, and it wasn't doing its job here. So the court granted the TRO and then the preliminary injunction, and then John died, and we got the death certificate filled out the right way. And then Ohio said, by the way, when we win this on appeal, we're going to change that death certificate back. So it wasn't moot. There's work to be done. And in the meantime, more people came to join Jim as a plaintiff. We had Robert Grunn, who was a funeral director. It was his job to fill out death certificates. He had a large gay community in his practice. And he didn't want to be filling these out wrong, and he wanted to represent his clients to get the ability to fill them out correctly. We had a whole group of lesbian moms who, had this unique problem. They were all pregnant, and this is where listservs are great. I wasn't on the listserv, but others in my circle were. And suddenly, kind of put out the word that here's some other variations of this. We just did death certificate. What about birth certificates? We had like 5 birth certificate clients where the woman would give birth. Ohio would put the birth mother on the birth certificate, but wouldn't put the married partner as the other, just the opposite of how they treated opposite sex married couples. And so we sued on their behalf. We had an adoptive couple that were adopting from Ohio, but they were gay and they had unique problems. We had the full range of people being screwed by Ohio for failing to recognize marriage. And all those cases were consolidated. We won at the district court level, and then Ohio appealed it all to the Sixth Circuit Court of Appeals. And meanwhile, similar cases were being litigated in Michigan, in Tennessee, and Kentucky, which are all the states that our Court of Appeals, headquartered here in Cincinnati, dealt with. And all the cases were consolidated. And all of these consolidated cases were set up for an argument on the same day. And it was quite a show, and the clerk's office organized where the clients are. They had extra rooms with video feeds for other people. And I said, I want the pregnant clients who have now given birth, because the case took a few months to get to the Court of Appeals, I'd like them in the courtroom with their babies. Oh, we don't do babies in the courtroom. Well, this is life affirming. This is really important for these children. I want the judges to see who they're impacting. All right, well, you can do it, but if they start crying, they have to leave. And all those babies stayed quiet through the whole argument. I was very, very pleased. They totally got on message. So that was really cool. But it was a very vigorous debate. And Judge Sutton, the chief judge at the time, believed that this shouldn't have been in court. That basically gay marriage is an issue for politics, and that people should just be left to vote on it. And he was very comfortable with the fact, and he used it against us, that there were some states that were voting to affirm gay marriage. He says, you're winning at the ballot box. What's the problem? And of course, the response was, this is a fundamental right. This is not the type of right that should end at a state line. And don't forget, on behalf of Jim and John, we started on marriage recognition. So, are you going to tell me that it's okay to go to another state, get married, but you're only going to be married in certain states, and then you're not going to be married, and then if you get sick, or your partner gets sick in the state that doesn't recognize gay marriage, and your thumb drive doesn't work when it goes into the computer to try and explain all your legal rights, you won't be able to say goodbye to your dying friend in that, or your dying partner in that hospital, whatever. It all made no sense at a practical level, but Sutton was very comfortable with that, as were a large group, within the whole country. And we lost in the Sixth Circuit. And that was one of the few cases at the time in 2013, 2014 that were losing, because gay marriage was on a roll after many years of very sketchy results. And then we got to the U.S. Supreme Court, and we were the first case to file out of that group, and that's why the case is called Obergefell versus Hodges. So what else?
Were you surprised? You were mentioning as people were approaching you, the funeral director and the group of lesbian moms, were you surprised by that reaction to other members of the public who had claim and wanted to bring forth a...
It was also logical. I was just glad that we could connect with all these people with real stories. This was not a theoretical problem. This was a very practical problem that impacted people's real lives. And that's what all those clients demonstrated. There was a national movement, which I had a great deal of respect for, and led by Evan Wolfson, who was the father of gay marriage, who envisioned gay marriage back in the 80s. I thought he was nuts. I was trying to just get civil rights for gay people. I was trying to get amendments to civil rights laws. He's talking about gay marriage. I was angry at him for a number of years because I thought his advocacy triggered the 11 states in 2004 that passed the marriage bans. They were in reaction to Goodrich in Massachusetts and to the Hawaii case. So I just didn't understand. But now I think he was brilliant because he was tapping into one of the most fundamental rights and institutions in our society. And why not just face that contrast, that opposite sex people have these rights, why shouldn't gay people have the same right? And the more I understood the impact of Edie Windsor's case, the more I met people like Jim and John, the more I saw how important this battle was and how right he was to pursue it. But when we filed, the national groups called and said, you're in sort of a hostile territory. You're not on our radar. And we don't think you really ought to be pursuing that case right now because we got a plan and you're not part of it. And that was unfortunate because, I said, well, you might have a plan, but I got a client and I got to represent them and the lesbian moms. And, these are all real people with real problems. So why don't we just work together, which we did, and it all worked out fine. But it was a little uncomfortable as we sort of ruffled the movement's feathers for a while.
I just want to kind of tap into how you were feeling while standing in that courtroom during Obergefell v. Hodges. Can you describe the feeling that you had that day? Were you confident? Were you nervous? Were you...
Sixth Circuit or Supreme
Sixth
Court?
Circuit.
Sixth Circuit. Well, I wasn't confident because I was nervous that we had 2 out of the 3 judges were not going to be favorable, and that's how it turned out. I felt confident in the argument, and if I listened to the audio tape, it sounds fine. We made our points, but it was clearly we were kind of banging on a door that wasn't wanting to open, and that was nerve-wracking. And the only good thing was that they didn't delay long. They ruled pretty quickly, which allowed us to get into the Supreme Court as quickly enough that we didn't have to miss a term of the Supreme Court, which was very, very important.
And then your feelings as you arrived to the Supreme Court. You'd been there before, but with this particular
what
case.
was interesting there is that more and more the Supreme Court has become sort of a specialized bar, and there are only a few people who argue in the Supreme Court anymore. And ours was the first marriage recognition case. There was a big debate about whether we should even pursue our theory, because that's only half the apple. If you don't win, the right to marry, then it all seems sort of half-baked. But, my theory was, well, this is what my clients needed, and why not have a backstop? Of course you're arguing for the right to marry, but, think about how unwieldy it would be not to have marriage recognition and how inconsistent it would be with Windsor. So there were two issues in the Supreme Court case. One was the right to marry, and the second was marriage recognition. Mine was the first case that brought that up. I should have argued it. And I was the lead counsel on the case anyway, so why not? But then Tennessee hired a ringer. Doug was a guy who had argued in the Supreme Court a zillion times, and he was like a pro. And I thought, well, I've really not done that. I've been there, but I haven't really done it like Doug has. And so we did a secret moot court in Nashville, I think it was, where he and I argued. We, in front of our clients, in front of a fake Supreme Court with all these law professors, just to see if I could do a good enough job to earn the spot. Because even though I could claim it, I didn't want to do it if I wasn't really good. So we did this, we videotaped, we both went into I didn't watch him, he didn't watch me, until we went in a room together and watched each other alone and talked. I just thought he did a better job. So he got to argue, I sat next to him. But the experience, and we mooted the case together all the way up. And when you're in the Supreme Court, the amazing thing is how intimate it is. I mean, they're right in your face. As close as you are to me, that's how close all 9 justices are. And they're arced, so that justice is like right here. And they're talking to each other, and you have to kind of jump in. And we felt good about the argument because we had anticipated every question except one obscure question from Alito about ancient Greece. But other than that, we had anticipated all the questions. And we didn't know for sure how it would all turn out. But we were glad to get to the court while Justice Kennedy was still on. We had great hope that Justice Kennedy would lead the court. He was the lead author on the Lawrence case. He was the lead author on Windsor. He was the lead author on Romer. We just felt that he would probably see his way to do this. And so we waited, and we're pretty excited when we finally got the ruling.
Can you speak to any maybe key legal strategies that you used in this particular case that were particularly effective?
Well, I had litigated abortion rights cases for 30 years. So I knew that abortion was totally anchored in substantive due process. And I didn't want to see gay marriage narrowly anchored. So I was a big proponent of using the equal protection arguments, like the one I was describing earlier, comparing gay marriage to the marriage of first cousins and to the marriage of young people. And that equal protection argument did survive all the way up through the Supreme Court opinion. And I think it has helped reassure some that gay marriage will be doctrinally more secure because it's well anchored both in equal protection and substantive due process.
And you spoke earlier about the consolidation of other cases. How well did you know the plaintiffs of those cases, or did you develop a relationship with them ultimately?
We actually created a working group so that our principal briefs were read by everybody, and then the amicus briefs would know where the gaps were. The parties who represent folks in the Supreme Court can't direct the amicus briefs, but if they see our briefs, then they know where the gaps are. So we had a very good working relationship with all the ACLU lawyers, NCLR lawyers, GLAD lawyers, Lambda lawyers, and had an internal working structure. I was very pleased with the collaboration and the professionalism that everybody showed through that very busy time of getting all the briefs done and making sure that we had agreed on the legal theory and where the emphasis should be. So that worked out very well.
And then you also represented additional defendants in Obergefell v. Hodges?
Not defendants.
Okay.
They're plaintiffs.
Additional plaintiffs, thank you.
And the plaintiffs were the birth certificate clients, the client who was had adoptive parents, the funeral director. Those are all additional plaintiffs. And there were people from other states who had their own lawyers. So it was quite a team. And we all spent a lot of time as we were mooting the arguments, and then we had time to gather as we waited. And I remember after the oral argument in the Supreme Court, we had a reception, and I brought Evan Wolfson up to the front, and I apologized to him in front of all the gay rights lawyers, and said, you know, I thought you were nuts, but now I don't. I think you're brilliant, and thank you for staying strong through all the losses for all those years. And even if we don't win, we've put on the best case possible. So that was nice to be able to honor him.
I'm curious, you know, you've talked about some of the challenges to legal theory and challenges to arguments, but I wondered personally if you felt there were particular challenges, even with the opposition, as they were approaching you and pushing back essentially on.
Well, two things. On the legal theory, one of the things I drew from my long practice representing inmates is the fact that the Supreme Court had recognized in the case of Turner versus Safley that inmates have a fundamental right to marry. And I thought, you know, if the Supreme Court thinks that inmates have a right to marry, including murderers and rapists and all these other people, you know, surely same-sex couples ought to have a right to marry too. So I liked, you know, relying on Turner versus Safley a lot. And there were a couple other marriage cases that I relied on a great deal. There was a case involving what they call deadbeat dads, people who hadn't paid their child support. And in Wisconsin, they were prohibited from remarrying if they hadn't paid their child support. And the Supreme Court said, no, the right to marry is so fundamental, we can't like make it contingent on debts and things like that. So those were strong legal arguments that kind of rose, that lifted gay marriage, the notion of marriage, the institution of marriage above all these, you know, little interferences like the gender of the participants. So that was very, very important when it came to the doctrine. And what was the other part of your question?
Well, just thinking about personally, any challenges from opposition. That,
So I mentioned that I make a point to structure cases so that we get to the merits and we get a ruling quickly. And I'm well known in Ohio as somebody who does that because I've been litigating for years. I had sued the governor and the attorney general. And I get a call from my lead opponent, the lawyer on the other side, and said, we have a problem. We're going to have to file all kinds of motions to dismiss because you sued the elected officials. And I said, I know, but they're also the highest officials and most responsible for implementing unconstitutional laws. And, you know, my opponent said, well, and this is all on the phone, we're not doing email here, we're talking as humans. She said, I know you want to get to the merits. I'm just telling you that I can't do that. I have to use my, you know, technical arguments to protect the elected officials. Okay, I said, then the real head of the, you know, the birth certificates, the death certificates, they all come out of the Department of Health. I could sue just the Department of Health, and that's a bureaucrat. That's somebody that these elected officials appoint. But I don't want you coming back at me saying I didn't sue the right people. And that's where the answer was, I won't do that. And I had to trust that. So that's a risk. And that's a risk you take because you respect the professionalism of your opponent. And I don't know if I was litigating that case today that I would take that risk, because we seem to have lawyers getting pretty deep into ideology rather than, having a certain level of ethics practice themselves. But at that time, with this opponent, I took that risk and we got right to the merits. They didn't file any motions. We were talking about gay marriage. We weren't talking about standing. We weren't talking about, legal, technical arguments. And that was pretty impressive. And I'll never forget that. And the other thing about my opponents that was striking was we get into court in Cincinnati. And not only did I have to sue state officials, but I had to sue Camilla Jones. She was the local registrar, because she's the one who actually signs the death certificate. And so I had to sue her to make sure she had a court order saying, don't sign it the wrong way. And that meant the city of Cincinnati had to defend their employee, because she was a city employee. So that means Cincinnati's in the case. And when Cincinnati came to court and got up, they said, well, we agree with the plaintiff. We're not going to defend this law. It's pretty cool.
That's fantastic. And I guess I have a couple last questions here. Just trying to tap into that feeling that you may have had walking in, attempting a landmark case, what it felt like winning a landmark case, and how that impacted your career.
I think one of the most interesting things to me was to work with all these Supreme Court litigators who were a pretty jaded group for the most part. And there's a section in the Supreme Court outside of the bench where if you're admitted to the Supreme Court, you sit with your colleagues. So I'm with all these people who argue cases all the time, and they're pretty stoic and used to hearing big cases. But when Justice Kennedy announced the decision in Obergefell, and it was clear we had won, these jaded, coarse, tough lawyers, a lot of them were weeping. It was something. It was history making. We knew this was big, and we were doing justice. That was cool. That was very, very moving, and can't be matched.
Do you feel that changed the trajectory of your career, or?
Well, I mean,
You've been doing
I
this.
don't know that I'm going to have another case like it go up to the Supreme Court, but I will tell you, I am furious at the way trans people are treated now. And I feel like we're having a redo on gay rights all over again. And I don't get it. I am absolutely astounded of the lessons not learned by the legal profession, by the courts, by legislators, and how easily we are victimizing young people, innocent people, harmless people, and purposely refusing to understand them. So if I have any juice left, it'll be to bring trans people up to the same general level that gay people are. And by the way, of course, we have lots of states like Ohio that still don't have gender identity and sexual orientation in its civil rights law. So we still have the potential for just regular old discrimination, which has to be fixed.
You may have said this, but from your perspective, what has been the most significant impact of the Supreme Court decision on the legal landscape of LGBTQ plus in the United States? I mean, you talked about some of the glaring limitations.
Yeah, I mean, understand, Obergefell made gay marriage legal across the country. The right to marry is legal across the country. and so is marriage recognition. But you saw on abortion rights, where I've been a player for years, that can be undone. So what has been most exciting to me is that Congress actually took the right step in December of 22 to pass the Defense of Marriage Act as a backstop to Obergefell. So if Obergefell were to be reversed in the Supreme Court, you'd still have the Defense of Marriage Act, which says that each state has to recognize any marriage that's legal in another state. So that marriage recognition argument that Jim and John and I started is now federal law. And it's not the best. We should just have it the way it is now, the right to marry. It doesn't go that far, but it's a workaround that will probably secure gay marriage as a practical matter going forward. To reverse the Defense of Marriage Act, you'd have to have the House, the Senate, and the President all sign a repealer, and that's going to be slightly less likely to happen for two reasons. One, 70% of the nation supports gay marriage. So who's the base? Two, the Defense of Marriage Act also defends interracial marriage. So you want to repeal it, you're going to say that black and white people can't get married and can't have their marriages recognized across state lines. So take that to the American people. And I think we're too far down the road to make that happen.
All right, so Al, I'm going to now kind of get us thinking about the present moment and looking forward. So I have a couple of questions I'm going to ask you in that realm. And I wonder, what is your hope for the future of marriage equality? What do you see as the next steps in the fight for LGBTQ rights? And you've talked a little bit about trans population, and I wonder if you can just kind of talk a little bit more specifically on what you hope to accomplish in your
Well,
work.
I certainly hope that there's no retrenchment on the Obergefell decision. There were hints in a dramatic dissent, which is frequently quoted by Clarence Thomas, Justice Thomas, and I hope it doesn't take root. And even when the Supreme Court repealed Roe, Alito in the majority decision made a explicit statement that this only applied to abortion, because that involves another life, given the life of the fetus in their view. So even there, they were hinting that this isn't going to undo Eisenstadt, isn't going to undo the right to privacy, it's not going to undo Lawrence, it's not going to undo Obergefell. That's what Alito was trying to explain. But the dissent was saying, well, you say that, but your doctrinal argument for reversing Roe would be the same for reversing Obergefell. And so stay tuned. I mean, we just don't know whether the Supreme Court is going to go the Clarence Thomas route or go the route of the majority in Obergefell and hold steady. I am hopeful that they will hold steady and not seek to undo the decision. And like I say, I'm glad that we have the backstop in the Defense of Marriage Act. So hopefully gay marriage itself will stay strong and stay available nationwide. But its tentacles should lift up trans people and should lift up gay people in other settings so that we have non-discrimination laws, and that's not happening yet. So we have a lot of work to do.
Al, do you think of yourself as an activist alongside being a civil rights attorney and being in the front lines with the work that you do in the courtroom?
Well, I hope so. I mean, I think I'm most helpful educating the public about basic civil rights, standing shoulder to shoulder with my clients, and I'm proud of the struggles we've been part of and will continue to be part of. And I think activists are needed more than ever right now. It's sort of amazing to see how blatant an attack on core civil liberties is underway right now. And we need to name it and fight it and use the courts as much as we can. I've been very proud of the legal profession for filing over 100 lawsuits since January to oppose some of the illegal actions of the current president. But I was also disappointed when a law firm got attacked recently, and the president said, anybody in that law firm can't go into federal buildings, anybody in that law firm can't take on federal clients. A law firm got attacked for who they represented, which is anathema to our work. I mean, we have a professional responsibility to take unpopular clients. That's John Adams, represented the British in the massacre, in Boston. So, we do this. This is how you assert rights, is by taking the unpopular position. And when that law firm was called out by the president, it took them a while to find another law firm to represent them because a bunch of lawyers didn't want to get in the crosshairs. That's scary. We should be clamoring to take on cases like that.
And as a mentor and speaking to students and just maybe individuals who aspire to be lawyers and attorneys, what is one of the most important lessons you hope to teach them?
Well, I'm in a very narrow view on law school. I tell people, don't bother to go to law school if you want to be a policy advocate. You're wasting your time. You're warming a seat that should be given to a litigator. I think that we need to go to court and sue people. And that's the true calling of an advocate. And if you're going to be a policy guy, then go do it. I mean, you don't need law school for that. And I really believe in using the courts to advance civil liberties, civil rights, bring civil rights cases. And I'm glad to see we still got a bunch of people out there that know how to do that and are in the process of filing those cases now. And we particularly, the other thing I do as a mentor is I encourage people to come to places like Cincinnati, Indianapolis, Nashville, Knoxville. I've been busy my whole career because there aren't that many civil rights lawyers between the coasts. And we need civil rights lawyers in the vast majority of the country. So you'll always be busy.
What message of hope or empowerment would you give to anybody who wants to join the fight for equal rights?
Well, in my work, most civil cases end with a damage award. They usually aren't like injunction cases. And so when I represent a victim of police abuse or a prisoner or somebody, her mom whose son was shot and killed by the police, a lot of lawyers just sue for money and then give the money to the family and that's it. Nobody feels good. Plus, the money was paid by an insurance company, so the cop doesn't even know what happened. So I always seek reform. And because the mom comes into me and says, yeah, I want fair compensation, but I want this not to happen again. And I take that last part seriously. My retainer with the client says we will do both things. So when we're mediating, or even after verdict, we'll say, if you want to settle this case or avoid an appeal, here are the reforms. This is what we learned in our lawsuit. These are the things you need to change in your community, in your training, in your rules, in your ordinances, to make this less likely to happen again. We've done that the whole time I've been in practice. And those reforms add up. And I point to those when I'm talking to young lawyers and say, you do that kind of work and you're making a difference. And so I encourage people to do that.
Can you speak more specifically about those restorative justice efforts that you've been involved with?
Well, the most dramatic one that affects us here in Cincinnati is the collaborative agreement. We sued after 15 black men had been shot by the Cincinnati police. We brought a racial profiling case. We brought an excessive force case. But very early in the case, an additional death occurred when Timothy Thomas was shot in April of 2001. And the city blew up with several days of unrest, lots of looting, lots of fires, violence. And we had given the city a choice right before this. We said, we can do this the normal way where we go to court, get an injunction, order you not to do bad things, and just fight. Or we can have a collaborative process where we bring all the stakeholders that relate to policing together and talk about our vision for public safety and for police conduct. And by a very narrow vote, the city council voted to join the collaborative. The FOP voted as like it was a contract, secret ballot, to join the collaborative. And we had 8 stakeholder groups. We met in houses, we met in public forums, we had online surveys. We did all kinds of things to tap into the energy of the city and the vision of the city and the disparate views of the various stakeholders. There was a white group and a spouses of officer group and all of us came together, and there were 5 shared goals. And everybody subscribed to those goals. Then we created a detailed implementation of those goals, a multi-page consent or settlement agreement that the court enforced for 6 years. The most critical thing there was that my client, the Cincinnati Black United Front, said, we want public safety, but we want to reduce arrests. And most people thought those two things were not compatible. But the truth is that if you use a strategy called problem solving, where you continue this very method of bringing stakeholders together, you can do that. And so for the last 20 years, we have been bringing stakeholders together around every discrete problem, whether it's an open-air drug market or a place, a corner where there's extra violence. And over those 20 years, arrests have been reduced in Cincinnati by 50%, and we are more safe. Crime is down. So we used to be, I've talked in gay rights about how we were an island of hate. Well, here we're an island of creative public safety because of those restorative practices. And I am having a hell of a time selling it to the rest of the country. I give talks. Iris Rowley and I go off and give talks. People just like using the hammer and think that arrests equal safety. And I am just having trouble convincing folks that that is not true. But we're working on it. And we've certainly proved it here.